need to submit to HRD. Every time need to record. Otherwise I cannot. Every time I need to submit to gain my points. I mean hours.
Hello, morning. My name is Azrin. I'm from engineering. My definition is paid for LMO and engineering.
Morning, I'm Shahrin from Medical Record Department.
Good morning to everyone. My name is Hannah. I'm from Nursing Department.
Hi, good morning all. I'm Ajianto from what
Good morning, my name is Hanifah. I'm from William. Yifa from Hi, I'm Tino, Physio and Rehab Manager. I'm Yogeshwari. I'm a medical nursery department.
Hi, I'm Kathleen, emergency department. Yes,
You're so awkward. You know me, they know me. I need to introduce.
so you need to register your name here.
Okay. To register, my name is Masita from HR.
Okay, so basically all of you are manager level, managing staff, at least one staff under you. Seorang je. Adalah gila dah ramai nanti kan ramai patient you perlukan because your department semua rekod kan yang okay I need some both languages Malay and so for today we will learn about empowering head of department, navigating misconduct, poor performance and grievance with legal confidence, a practical guide using real court cases. Okay, how many of you have experience attended court? Either be witness, which court? Industrial court or civil? Criminal. Okay. Actually, we already introduced.
Yeah, I'm Ryan. Yeah, head of corporate service in B.
Okay, so my industrial court, labor. Okay. Does anyone know what's the difference between labor court and industrial court? Because when I asked the industrial court, she said labor court. Anyone know the difference? Industrial court? Okay, we will learn about it today. Okay, I'm sure all of you experience handle your staff problem. At least legal time. Right? Okay. Before I'm going to start today's session, I would like to give you pre-assessment training question. 20 question. Please answer. Just take 10 minutes. Very easy and practical question. Okay. Based on your experience, from there we know. Okay. Simple question, not advanced and no ChatGPT. No ChatGPT. Honestly, from your experience. No Google sister, no ChatGPT brother. whether this particular issue is misconduct or poor performance or grievance. Okay, there are different ways to handle it. Then you will learn what is the rights of probationer, what is the rights of retirement person, and what is constructive dismissal, what is non-fixed term contract. So I holistically going to cover everything with decided case law. Okay. Number one, what is misconduct in the workplace? Randomly can answer. Okay. Breaking workplace rules or standards. What does poor performance mean? Very good. A. Number three, which of the following is reason why employees might raise a grievance? Okay, grievance means you are not happy. For example, your boss is favoring one employee, didn't give many tasks to complete, but with you, unfair and giving a lot of tasks. So those are the grievance. Or you and your colleague are doing same task, but your colleague's salary is 8,000, your salary is just 2,000. Those are the discrimination. That's our grievances. Okay, which is the best way? Sorry, which of the following is the reason why employees might raise a grievance? Okay. B. Which is the best way to handle poor performance initially? Initial means beginning stage. Yes. Discuss the issue, provide support. If an employee breaks the company rule, what should the manager do first? C or D? Confidently, C or D? Very good. I can see you all are good managers. Okay. Number 5. If an employee breaks number 6. What is a common cause of poor performance? Very good. When handling a complaint, what is important? Good. So it's like you are reducing HR work. Why is clear communication is important when managing staff? Very good. Which of the following can improve staff performance? Good. B. What should the manager do when an employee consistently fails to meet target? Very confident. Manager, employee, HR. HR is totally third party. But most of the cases, they will blame HR. Oh, you hire wrong person. But when hiring time, use it for the interview, you assess the candidate, but blame go to HR. It's a universal problem. Okay, which one is the right answer? B. Talk to them, find out why. Okay? If you do A, what will happen? Immediate termination? No. Industrial, you will receive a letter from IR department. Okay. Number 11. If an employee raises a concern, what is the manager role? B. Okay. Depends lah, depends. Okay. Okay. Number 12. Who is responsible for setting clear expectation? A or C? Really? Okay, good. C. Okay. HR facilitator and also creating policy only. Okay. 13. Who is generally responsible for the performance and behavior. Very good. B. Okay? I'm glad you all know. Number 14. Who usually handles the initial step of addressing staff performance issue? Very good. Number 15. Who provides support and guidance to HoD on employment related matters? Good. HR. Okay? Because they are the policy creator. Okay? 16. When an employee is unwell and unable to come to work, what type of leave should they usually apply for? Sick leave. Which type of leave is typically given to a female employee who has just had a baby? Huh? Maternity. Had a baby, okay? What is paternity leave usually given for? Paternity leave is a new, under the new amendment. Paternity leave for? Yes. B. What does it mean when an employee is on probation? Probation means what? Employee is under trial. Under trial, okay? Under trial, okay. Monitor the trial is the better way. Okay. Which one? Yes. How long is the probation period usually? How long? Very good. 3 to 6 months. C. Okay. Very good. Don't 400. Okay. Let's start our training. Now, usually, what HoDs think? So any small problem, okay. Usually, what HoD will think, any small problem must refer to HR. But actually, who HoD is managing the staff directly? HR is the third person. So we must make sure HoD equipped with all the knowledge to manage the staff before we refer to HR. When HR will come into picture when the matter goes out of your hand or serious matter. Other than that, HoDs can handle. Let's start. Primary labor laws in Malaysia. These are primary labor law in Malaysia. Number 1 is Employment Act 1955, which all of us are using. Why? Because it only applies to Peninsular Malaysia. For Sabah and Sarawak, they have their own labour ordinance. Employment Act 1955 basically states about wages, working hours, overtime, annual leave, sick leave, and termination. Industrial Relation Act 1967 is applies throughout Malaysia, including Sabah and Sarawak. Okay, what's the main purpose of Industrial Relation Act? When we terminate an employee, if that employee feel the termination is unfair, then they will go to industrial department, then industrial department will refer to this act. When you go to industrial department, what industrial department will do? I will share my slide for you after the session. I will give. Okay. What everything I don't amend anything, I will just email to you. So call as a reconciliation. That's the term for the meeting, reconciliation. They will call employee. They will talk ask them to reinstate back the staff. If the relationship is really sour, cannot reinstate back, then they ask for some compensation, provided the employee didn't do any wrong. If do wrong means, then can no reinstatement and no compensation. If both parties cannot reconcile, then they will refer to industrial court. Second process. First, they call for meeting. The meeting not successful, then only they will refer to court. Okay? So this is the primary labor law in Malaysia. How about the other related law? You all know, if you all refer to your salary slip, you will notice EPF, so EIS. Right? So those are the related law. It's a secondary law, not a primary law. EPF, you all know, is a compulsory retirement saving plan. SOCSO also is a compulsory deduction just in case we have any injury or illness, then we can claim SOCSO, provided we are under employment. If you are not under employment, then you cannot claim. EIS is the insurance scheme. If we are retrenched, then you can 6 months they will pay you your salary. I think first month full salary, second month is they will deduct, they will reduce according to the month. So that's the purpose of EIS. Only for the retrenchment. Okay, it's an insurance. So okay. Doctor, you okay about your procedure? With your teeth. They are warm. Okay, this additional information just for a general knowledge. Have you all heard about civil court, right? Civil court. So now you are working in a hospital environment. When a patient want to sue you, they will go to industrial court or civil court. Patient suing hospital. Civil court. Why they don't go to industrial court? Why? Why patient cannot go to industrial court? Exactly, very good. Because patient is not our employee. Okay? So, this is the civil court structure in Malaysia. Magistrate court, you always hear about magistrate court. Magistrate court, high court, session court, court of appeal, federal court. This is the fixed civil court structure. Magistrate court and session court, subordinate courts means lower level courts. Depends on your claim. For example, your claim only 5,000. Your lawyer will file your case here. Your claim is 2 million. Straight away High Court cannot claim here because no jurisdiction to hear. Up to 100,000, 1 million, above 1 million. 1 billion, where to find 1 billion? Sure? Yes. Why cannot go to federal court straight away? Not court of appeal? Yes. See, appeal. Function of court of appeal, only hear appeal cases. If court, okay, high court, judgment, you are not happy. For example, High Court gave death sentence to the murderer, not happy. Then appeal to Court of Appeal. Court of Appeal also say, no, death sentence. Still not happy. Appeal to Federal Court. They all cannot hear new cases. Just one or two exception only can hear to Federal Court. Must get permission. Okay? Magistrate, Session Court, judgment not happy, cannot straight away go to Court of Appeal, must go to High Court. Appeal, High Court first, then only. Not happy, Court of Appeal, not happy, Federal Court, not happy, Federal Court, where can go? Huh? Supreme Court, World Court. Any other courts? Death sentence what? Wait for your timing only. In 1978, for the criminal cases, before 1978, criminal cases can go to Privy Council. We all are whose colony? British colony. So we are Commonwealth country, right? So we are allowed to go to Privy Council, which is in UK. Can appeal that. 1978, our tool. Because we want to make sure our judiciary is more powerful. We don't want UK law to govern us. That's for criminal. Civil, 1985, stop. No more Privy Council. So, life or death, here only. Unless King give you pardon. Okay, this is additional information why I want to share, because where is the industrial court? We have here industrial court, tribunal. Who knows? Tuntutan tribunal pengguna. Anyone knows what tuntutan tribunal pengguna? TTPM, consumer claim, and sexual harassment court, tribunal sexual harassment, right? Recently they enforced. Where they park? Under magistrate. Magistrate. This table magistrate. This table Federal Court. Session Court. This table Privy Council. Magistrate. Right. Where actually they are out of this court system. If you want to go to that court system, you cannot enter without a lawyer. And legal fees is killing nowadays. Okay? Outside of the civil court structure, you can go without bringing a lawyer. You can go defend yourself. Only company must hire a lawyer. Individual like us, just go without hiring a lawyer. Zero, no payment. If you want to hire a lawyer, can. That's up to you. If not, you can defend yourself. You can defend yourself, no payment, and the process is speedier. And the decision is binding. Must bind. Binding means the decision is valid. If the industrial court asks the company to pay you damages compensation, company must pay. Okay, it's totally outside of the civil court structure. Civil court structure, always remember, you cannot go without a lawyer. You can defend yourself, but the process is tedious. You will give up eventually. You don't know which paper to add on to that. Now, online, e-review. Only lawyer has the access. Okay, here, just walking. Just walking. Human Resource. Labour Code established under Employment Act 1955. Industrial Code under Industrial Relation 1967. Now, have you all seen Mahkamah Perindustrian? You all have seen, right? Under Potaso building in, I think in Sreman, right? Have you all seen, right? Okay, next time we go. Okay. Who have seen Labour Code? I want to know. Who have seen the Industrial Code? Mahkamah Perusahaan. We have seen everywhere. Who have seen Labour Code? I want to see that person. Tak pernah. Sebab tak ada. Memang tak ada. It's just term only Labour Code. Actually, that's a Labour Department. Function as a code. It's not a real code setup. Industrial Code, real code setup. How you all seen in the movie. Witness stand. The judge, the setup. That's a Labour Code. Sorry, Industrial Code. Labour Code is a Labour Department. But they will declare them as a Labour Code. It's not a formal code. See? But their decisions are binding. If your employer didn't pay last month's salary, then you need to go here. Because salary problem, discrimination problem, here only dismiss. Other than other issues, here. This one only when come to a dismissal. You must have a dismissal letter. Within 60 days, you must file your case. If you pass your 60 days, what will happen? Pass your, you missed your 60 days. You cannot go here, but you can still go to civil court, but with legal fee. Okay? So don't miss your date. This one is a formal code. Okay? All the setup. Okay, now. See, types of employment contract in Malaysia. Contract of service, contract for service. Have you all heard that two terms? Contract of service, contract for service. Okay, contract of service means employer-employee relationship. Okay? Example, permanent employee contract. Statutory deduction will be in your salary, is a must. Fixed term contract with statutory deduction, EPF, SOSO, EIS. Probationary employment, probational, also contract of service because employer will deduct EPF, SOSO and EIS. Part-time contract also, they will deduct EPF, SOSO, EIS. That's a contract of service governed by Employment Act 1955 because employee-employer relationship. How about contract for service? Contract for service is an independent contractor. Okay? They are not governed under Employment Act, but their contract governed under Contract Act 1950. Example, consultant, Dr. Satish. Okay, Dr. Satish is not our employee, but he is our independent contractor. No statutory deduction for him. Yes, ma'am? Actually, I cover everything today. Then I will give this slide. I will remove the upper, I will give 100%. Okay, now, recently, Employment Act 1955, we had a major amendment, right? You all know, right? 2023, major amendment. Why? No, okay. Why we had this major exercise? Because we want to comply with International Labour Organization. It's more on trade, because Malaysian products will buy by other countries, right? If we have a forced labor or child labor, we are not up to international standard. Countries like UK, US, they will reject Malaysian product. To make sure to comply international labor standard, what our government did, they included certain major amendment to Employment Act 1955. Sabah and Sarawak is working on it. We already done. Peninsula is done. Sabah and Sarawak is working on it. Okay. See, they want to prevent trade sanction. If trade sanction happen, economically we will go down. Our product, countries like Europe, they don't buy our product. So that's the main purpose, trade purpose. For hospital setting, for example, hospital might employ foreign workers, cleaners or nurses. So one of the element is forced labor. Forced labor means we using threatening or just we keep their passport, didn't give them freedom, force them to work. To prevent that, then Employment Act emphasize we cannot do that. If we do that, then they will impose high penalty. Okay, so that's the reason for the major amendment. Okay, it's effective is January 2023. Okay, okay. I just want to ask one question. Before the amendment, Employment Act 1955, who are employee under that category? Now, all of us except Dr. Satish are protected by Employment Act 1955. Before that, before this amendment, who are protected? Only staff earn 2,000 ringgit, and also despite earning more than 2,000 ringgit, manual laborers are protected. Who are manual laborers? Manual laborers are using their body to work, not intellect. Doesn't mean they are not smart. They are still brilliant, but they are the working style like drivers. Okay, drivers, cleaners. So they are manual laborers. Even though they earn more than 2,000. That's the old law before amendment. Now, after the amendment, employee. Okay, which act I'm referring now is, you can refer to the blue color. I will cover the Employment Act 1955 first. Okay. Under this act, employee means refer to this first schedule. Employee means actually all of us are additional protection. Okay, see, applicable for all employees. However, the person who earning 4,000 and below, if you earn 4,001 ringgit, then for benefit you are not entitled. I will show you what are the 4 benefits. And also manual labor. Manual labor protected if they earn 10,000, 20,000, they are entitled for the protection also. Like basically all of us are protected. Okay. See the scope of application. The Act now applies to all employees, regardless salary level. But some specific benefits only apply to employees earning 4,000 or less. Okay? Also, manual labor. Only these 2 category people enjoy these benefits. Overtime, shift allowance, termination benefits, retrenchment benefit or and layoff benefit, additional pay on if they work on rest day, work on public holiday. If anyone earn more than 4,000, they cannot enjoy this. I was is very sad. Okay? Okay, I go back. Go back. Okay, now you know who. Now I will send to all of you. Now you know who are employee. Everyone, all of us are protected. Okay? But this Act gives additional protection for 2 categories people. Some benefits. Who earn 4,000 and below and manual labor. Okay? Simple as that. What are the protection? This one. Can claim for overtime, shift allowance. Termination benefit means if situation not involve any misconduct or poor performance, if your employer terminate you, then they will give.
This one, the 4,000 again, is basically on total all the allowance.
Pay is paid for the additional hours. Normal working hours is 8 hours, right? You not 8 hours. Then they will entitled for 1 hour overtime.
What means for the benefits? For example, you said more than 4,000 again, the salary is more than 4,000, they cannot take all the benefits, right?
No.
Yeah. So if let's say that 4,000 again, we take it from the basic itself or with the basic salary, not the allowance, right?
Basic salary. Fixed allowance also included. Given the EPF, the deduction, right? Statutory deduction, EPF, we include basic wage and also allowance. So then, so safely can say we go to the basic lah usually. Okay, because the act also say like basic wages lah salary. Okay, any question? Employment Act, you will find the word contract of service, meaning to say employer-employee relationship. Okay? So must enter into a contract. Like for example, all of us has letter of employment. That's a contract of service. Independent contractor. I'm going to show that case. Can manager, CEO, position? Oh, the question is, Dr. Santi is asking whether independent contractor can get that managerial position, like CEO position. Can, really can. But that's my appointment, right? He can become a manager level or CEO level title.
As an independent consultant, can use the manager or CEO or COO title.
You mean that, right?
That's why my opinion is depending on whether you are the contract of service or contract for service, regardless of what is the title, right?
I think can, because the medical director previously is working independent contractor, but the only issue is if let's say they sue, right, as a director, the hospital, if I'm the director, because usually let's say because orthopedic surgeon gets sued, the hospital don't get sued, only the orthopedic surgeon gets sued.
That's why I refer to the contract, what type of the contract.
But if let's say I hold position like director or something like that, if I get sued, basically the hospital gets sued. That's how the thing works, if I'm not mistaken.
Even the current law is hospital also vicariously liable. It's not only you. Hospital will become one of the party to the legal dispute. That's the new case, new judgment. Federal court judgment. Early of this year. The only thing, the indemnity will be different. Like you have your own indemnity, hospital have their own indemnity. Hospital indemnity won't cover you because you have your own indemnity. Okay, contract now. Sorry. Okay, contract of service, is our letter of employment. Okay, what do you think? Is a nurse is a manual labor? Nurse. Yes, but not applied to the administrative level nurses. So that for benefit cannot. Yeah, that's why. Depend of their nature of work. To get the benefit, you must attend the patient and do whatever the basic nurses task. If nurse manager is managing staff, right, then not entitled. They are not a manual labor. Okay?
Are they considered professional?
doing manually, right? Even though chef also manual labor. Okay, so okay. But we will see that, yeah, really, I agree. The title, nature of the work, yeah. But if they involve in administrative work, but so nature and so like even our hospital, do we have this overtime payment? Because this is law, but how they implement? Yeah. Because law, see, when Parliament enacted law, they cannot foresee what, how things will work. That's why they will always come on with the orders, like different orders or policies, because they want things to work well. This is what on the act. Okay. See, lot of rules, why they created, because Parliament cannot foresee everything when they enacted any act. There is another category of employee, apprentice. Do we have apprentice in our hospital? We don't have. Also they are employee. Okay, they are also employee. They come to get training. For example, nurse apprentice, they will get training. Okay. Intern is different. Intern is not an employee, but they are employee. Intern is different. 2007, right? This is the latest one. 2008 or 2007? 2007, right? 2008 and 2008, right? 2007. But now they want to make it 25. 25 lah. Okay, because of the economic situation. Okay, apprentice, minimum duration, because they come to get trained under specific field. Okay, so the minimum duration 6 months, maximum is 24 months. They are employee. They will get basic salary, minimum wages, eligible for EPF, SOSO and EIS. Okay. Part-time employee. Part-time employee, also employee. Okay. Part-time employee is someone who work less than full-time employee. Their work is like more than 30%, less than 70%. That's a definition from the Act. Okay, don't give 100% full-time job to the part-time staff if you have. Okay, so you must manage their job scope 30 to 70. Okay. That's a part-time employee. Okay, now, since this is purely for hospital cleaning, let us see hospital setting employee. If I missed out anything, actually we all learning each other, you all freely can ask me or tell me, teach me also. Okay, now, see, all these are category of employees under hospital setting. Permanent staff like Ms. Mazni, probationer, you all know, we hire them 6 months probation. The new employee is a probationer. Manual worker, cleaner, ambulance driver, okay. Housemanship. Housemanship is a compulsory medical training in hospital under Medical Act 1971. Okay, they also employee. Also, pharmacies provisionally registered means they also under training. Also, they are employee, and apprentice also employee. These are the these people are not the employee. Locum doctors or locum pharmacies, any outsourced staff, volunteers, intern, clinical attachment, consultant specialist is an independent contractor. Okay, all these people are not an employee. Okay, anyone I missed out? Locum is a qualified doctor, right? Qualified or medical practitioner. They will replace a doctor or pharmacy or radiographer whenever they go for off visit, just for a few hours or a day. Part-time. They are not fixed with hospital. They will come. We don't have any fixed person, right? Like what I understand. Maybe Dr. Shakti can correct me. You all have a WhatsApp group, right? You all can WhatsApp them. Whoever free can. If you want to go for leave, or if you have fixed person, then okay. Here LB, how they practice, they will have a group of doctors go for locum. They, okay, for example, tomorrow I want to go for leave, I will WhatsApp them. Whoever free, they will come. Like part-timer with the employment contract, they don't have. It's just out of curiosity. For example, okay, you're off today. Which doctor? Okay. Dr. Jaya, she's my mom's doctor. Dr. Jaya, please, just for example, provided another person doing her job, but it's a hospital between her local fee because her salary is ongoing, right? break at 10:30. So okay, or 11? 11, okay. I cover first part. Okay, now. Okay. Actually, passport they should hold, the owner should hold. Okay. For the hospital employee work structure, right? Because hospital, we are operating 24 hours, right? So like regular working hours, like regular staff, like IFA. Shift work, normally for the nurses and also doctors also. Okay, who has radiographer, pharmacies, oh yeah, pharmacies. Okay, billing clerk. Okay, on call duty for doctors. Who else? Only consultant. Consultant means specialist. Then the 9 to 5 non like NO, not on. Okay. So like here we don't have shift, we don't have on call. This is a hospital setup and structure. Okay. We look at this case. For this case, right, the key legal issue is whether the claimant was a workman. Workman means employee or independent contractor. Okay? If you are seeing this, this is a judgment. This is a judgment, industrial court judgment. Okay, that's a case number. This case is between Arun Kumar. Arun Kumar is a claimant, employee. Okay, he is the one want to claim something from the employer. Okay, against Hospital Pantai Indah, Sendirian Berhad. Okay, why Sendirian Berhad is there? Why not only Hospital Pantai? It's a company. Company is a entity. Okay, company is like a legal person, entity. We only can sue the company. If you anything, I only can sue against UCSI Hospital Sendirian Berhad, not UCSI Hospital. Okay. So who is the judge? Tuan Gulam Muhyadi. Okay. For the industrial court, we name judge as a chairman. We don't call them as a judge. For magistrate court, we call the judge as a magistrate. We don't call them as a judge. Session court onwards only we call them as a judge. Session court judge, high court judge, court of appeal judge, federal court judge. For industrial court, we call them as a chairman or chair lady. Okay, let's read about this case. You know the story? I highlighted important points. Okay, let's see what is his claim against the hospital Pantaya. Actually, this doctor stay in my area. Okay. He filed a case against the hospital under Section 20 sub 3 of the Industrial Relation Act 1967 because he was dismissed by the hospital. Dismissal. Arun Kumar, claimant, Hospital Pantai Indah Senya Berhad is a company. When they dismissed him on 28 February 2006. Okay. Let's see what happened. This doctor, claimant means that doctor is a full-time resident, same like Dr. Satish. He saw advertisement, then he applied for the job. And he got the job. So when he want to practice in the Pantai hospital, then the company say you must kiss your private hospital. Okay, he must stop work there because full time one. He must join here. So we also do the same, right? We also do the same. Okay, they must kiss his private practice. Must become a full-time resident consultant in the hospital. Then he agreed. They signed consultant agreement. Our agreement also consultant agreement. Okay. Then what happened? He signed on 31st December 2002, but he joined on 6th January 2003. The 5 days after 5 days he joined. He commenced his job as a full-time resident. Okay? Now, in the terms, okay, when you sign any contract, sure, there are terms and conditions to follow, right? Even our letter of employment, salary, working hours, entitlement, same. Under this consultant agreement, there are certain terms. One of it is all professional fees charged by the claimant in respect of inpatient and outpatient treatment shall be billed. Okay? It relevant to Dr. Satish. And that contract only for the duration of 3 years. Do we have a duration? 3 means we are employee, Dr. Satish. We are not like you, we are independent contractor, business partner with hospital. It is no bully. Okay. For permanent staff, okay, fixed term, yes, we have like 1 year fixed term. Like permanent staff like me, when I receive offer letter, I don't have any ending period. Okay? So after probation, I receive my confirmation. Okay? So we don't have ending period. But for the fixed term contract, yes, 1 year, 2 year. For the contract, just now, how Dr. Sati said, yes, they will have ending period, then up to the parties to renew it. he can ask for renewal or hospital. Okay, if either party don't like to renew, then we can apart. Accept friends. Okay, so same, in this contract is a 3 years. If the claimant, if the doctor want to renew, continue beyond 3 years, what he must do? He must write to the company. Write to the company. And also another term is claimant also sublet clinic space. Like a doctor's independent contractor, the doctor, they will pay rental to the hospital. Hospital is facilitating for the specialist. They will pay rental, they will do their business, and they will get their payment. That's how all the private hospital. So this doctor also same practice. One of the term he must pay the rental. Okay, how much? 2,500 per month. Okay, and specifically mentioned in the contract, claimant shall be an independent contractor. Okay, it's mentioned there. And also specifically also mentioned not entitled for any statutory benefits. What are the statutory benefits? EPF, SOCSO, EIS. Everything spelled out clearly in the consultant agreement. Okay, now due expired. Company decided to inform him not renew. So the doctor then upset angry. For him, unfair dismissal. He all this while think he is an employee. That's why he filed a case. Okay? Now, so they not renew, not terminated, non-renewal, because the contract duration is end. So now, the doctor claimant claim to the court he was dismissed without just cause or excuse, means without valid reason. He got dismissed by the company. Okay? Now, see what usually the court do, court will check first whether the company dismiss him without just cause or excuse. If yes, then they will seek for reinstatement, means they will ask the company to take back that employee. That's the industrial court function. That's their first option. If that first option didn't work out well, because maybe both of them fight, relationship turns sour, then you cannot work there, right? And only they will go for compensation. Okay, now I want to go to law. Okay, let's see what's the company argument. Earlier you saw the doctor's argument. Now let's see the company argument. Now the company argue, I will share these cases also with you with the highlighted part. You all can read it. See, the company is arguing working relationship between the claimant and the company governed by the consulting agreement which came into force 2003, and the company say clause 11 specifically mentioned he is an independent contractor. Also, the consultant shall be the independent contractor, not the agent. The consultant also responsible to conduct his behavior. Okay? And under 11C, the company say the claimant shall not pay any salary or allowance entitled for the statutory contribution. All these are company's argument. And also, the company say under the consultant agreement also provided a tenancy of a consultant suit. The claimant required to pay 2,500 because renting space, right? And also the claimant was not expected to observe any specific working hours. So this is their argument. So what the court say? Okay, let us see what the court say. Okay, evaluation and findings of the court after hearing all these. See, this court holds that there was never an intention on the part of the company to create legal relation with the claimant on the basis of a relationship of employer and employee. In other words, the claimant is not considered as a workman under the Act. So, the claimant case dismissed. Because industrial court cannot hear, they only can hear employee cases. This doctor is not an employee, so they dismiss the case. But he can go to civil court. Any question? One more case, then we can go for coffee break. Section 10 of the Employment Act is about any contract must be in written. Employment contract must be written with termination clause. It's very important. Okay, there must be a termination clause. Okay. How and also the duration, especially the duration, how the notice period. That's section 10. Section 11 is about termination, provision as to termination contract. See, for the fixed term, there will be a specific period of time. Because there are two types of contract, right? One is fixed term, another one is unspecified duration. It's a permanent contract. Okay? So, section 11 specify when the contract period expire, and also for the unspecified duration permanent contract, it does not specify the duration. Only the fixed term is specified duration. So it's governed under section 11. Section 12 is the notice period, but this is a guideline only. If any employee, okay, whether employer or employee, both parties can terminate the relationship. If you want to terminate less than 2 years, 4 weeks, 1 month notice, 2 to 5 years, 6 weeks notice, 5 years or more, 2 months notice. It's a guideline, but depends on your contract. If your position is a managerial position, usually 3 months. If management level, 6 months. Depends on the company. If there is no duration specified in your contract, then this will be the guideline. That's the purpose of this. Sometimes missed out the duration, then you can use this. Okay. Section 13. Actually, it's important to specify in the letter of employment.
So if there's no ambiguity that you must specify in the offer letter, it's a good practice to specify in the offer letter.
No. Under section 10, just now, the termination must have a termination clause. If you have termination clause, it's come together with notice period. It's good to state in the offer letter. Offer letter is the main document. Okay. Section 13 of the Employment Act is about both parties can end relationship without notice. No need to give notice when you want to end your relationship. But if you want to do that, must pay the notice period. For example, the employer wants you to leave, but your notice immediately, your notice period is 2 months, then your employer must give you 2 months payment. If you want to leave immediately because you have another option, then you must pay your notice period. Okay? We call it that as a payment in lieu of notice. Okay. Next, under section, the one is part A. Part B is willful breach, both sides. Example, employer didn't pay your salary, then you can immediately end your relationship, or employee absconded. Then there's a willful breach. Willingly you breach terms of contract. So that's a willful breach. So that's under section 13. Now come to section 14 is where the usually employer will use for the misconduct or poor performance. Section 14 is a termination of contract for special reason, either misconduct. If misconduct, must do domestic inquiry before termination. If poor performance, must do PIP, performance improvement plan. Okay? Compulsory. For the performance issue, no need to do DI. PIP enough. Only for the misconduct, DI is mandatory. The first question industrial court will ask whether the company has done DI or not. Okay? Next, section 14. Under section 14 sub 2 is about suspension of the employee pending inquiry. Why for certain cases we need to suspend employee? Why? Just give them a rest after their misconduct. Yeah, investigation. Yeah. Why we need to suspend them? So that they will disturb the investigation. They will disturb the evidences. But suspension with half salary. Suspension with is a kind of holiday, but half salary holiday. After the investigation, if the employee find not guilty, the half must go up. If guilty means no need to go up. It's a kind of punishment. Okay? So okay, there's section 14 sub 1 sub 2. Section 15, AWOL. AWOL is a famous term, right? Have you all heard AWOL? AWOL means absence without official leave. Just disappear like that without informing your boss. After 2-3 days, balik slumber. Okay? Okay? Attempt to contact pun tak nak jawab. Okay? Yeah. Actually need to call. Okay. Done. Section 15 is contract deemed to be broken. Deemed means anggap sebagai. Deemed means menganggap sebagai no more contract. Divorce. Okay, broken already. In two situations. Okay, first, employer breach. If the employer didn't pay your wages now, because we work for salary, right? Employee part, without leave or valid reason, you just absent for 2 consecutive days. Consecutive day means continue. Not Monday hilang, Tuesday balik, Wednesday hilang. No, Monday and Tuesday hilang terus. And also attempt to your HoD, attempt to contact you, cannot reachable. No news, 2 days. Consider AWOL. And then management cannot straightaway terminate you. Must go through process. First they will send AWOL letter. After this, some of the employees, after this AWOL letter, they will come. Then up to the management, HoD, whether want to accept or not accept. Huh?
How many employees you present the evidence that you have called?
Screenshot pun boleh, WhatsApp pun boleh. Because nowadays WhatsApp considered as a official document. Also can admit as evidence WhatsApp.
Usually how many
case happened in our school. Teacher disappeared. Just disappeared like that. School trying to call them because teacher is very important, right? They need to manage the kids. Homeroom teacher means class teacher. One day passed, no news about him. Then police called, hey, your staff under detention. Because he cannot contact you, then police called, your staff under detention. Then they will give information lah why under detention. So that's exception lah. But then if found guilty, then we can terminate. Until proven guilty, they cannot terminate. Okay, there's another story. So what we can do? Try to call or message some sort of proof before we terminate that person. Because the court will ask, oh, so tunggu je ke untuk legally lah, at least show lah some this one, kan? And is this one considered breach of contract? Breach of contract. Okay, so termination 3 times. Section 30, okay. Section, okay, I just overview. Section 10, every employee must have contract. Contract with termination clause. Section 11 is about fixed term and permanent employee. Fixed term means with duration, permanent employee unspecified duration. Section 12, the notice period. 2 years, 4 weeks, 2 to 5 years, 6 weeks. Then above 5 years is you must give 8 weeks notice. Section 13 is about the willful breach. Both employer and employee can apply to both employer and employee. Section 14, always remember that's the common section used by the employer for misconduct and poor performance. Complete suspension. Section 15, AWOL. Remember the AWOL. Deal broken. Menganggap apa relationship dah tak ada. But provided you attend to call them lah. Apa yang kita nak cari? Okay. Okay. So next section will be section 37, which we need to know. Here, maternity leave and allowance. What are the rights? Okay. What's the old entitlement maternity leave? Berapa hari? 2 months. 60 hari kan? 60 days. Current act is 98 days. Okay? 98 days. Okay. During the maternity leave, employee entitled for salary. We call as the allowance, but actually that's the salary for the 98 days. When the leave will start, maternity leave. Okay, before that, your total leave is 98 days kan? Total 98 days. After 1 month or 2 months, you feel boring, stress with the baby. My daughter 12 years old, so at that time memang stress lah. Kan, sleepless night, then stress. Okay, so memang stress. Nak balik kerja, betul kan? Balik kerja, sekarang lagi besar lagi stress. You be a mother, you know the stress. Tengok, looking at me, my daughter always want to eat. I need to cook. Ayo, okay. Back to our story. 98 days, stress. Ya, memang stress giver. Okay, 40 hari. Can, provided doctor must give certificate fit to work. And also your employer must agree. But she must voluntarily decide. It's not you call, rasa you boleh balik awal lah. Cannot. Then woman must voluntarily want to back to work. I tak pernah baca. Content semua I belum pernah baca. Tak ada chance tapi I kena baca juga lah. We are stressed with them. Private, I think some people. Okay. Another important item you all need to know. Maternity, you can get maternity leave. How many kids? The one provided your 6 kids or 7 kids, 98 days, you can still get. But the allowance, salary, if you give birth to your 6th child, you have 5 surviving child, all 5 kids must be alive. For the 6th kid, you cannot get the maternity allowance, no salary. Better you save the money before you go for 6th birth. Company takkan bayar. 6th one. 5th one must be still alive. So now your number 1 is ready. Number 1 is okay. Still got one. I know you are not an employee. You are business partner. Kita je employee. Okay. Specifically mentioned, no maternity allowance if 5 or more surviving children. Okay, another example. But you can go for leave. Leave, you can get 98 days leave. Only thing the salary, no salary. No salary for 98 days. For example, you give birth to twins or triplet, then you still have only 2 chance. Count as a 3 surviving children dekat. Actually gaji, tapi mereka dalam akta pun sebagai allowance sebenarnya gaji. Second one is secara count only for Muslim people and count as a not this one kind is always there is Father get 5 surviving children. For example, the second wife 3, first wife as relevant. First wife 3, second wife 2. Already 5 surviving children for the father. The second wife again pregnant for them. But for her is third one lah. She can get, but father cannot get because it's 5 surviving children. Kenapa mereka semua tolong tanyakan untuk you? Jom kita bincang. Okay, yang tu nanti kita lagi. Okay kan? Very good. The next I want to read. Okay, because my last month I had the same program I just for this university care people. We raised this question. At that time, we had a few discussion. Okay, during maternity, macam alien sound. Hello. During maternity time kan, mereka boleh tender resign. example, the 98 days, they tender, company cannot reject. We must accept, provided in the acceptance must clearly specify they must back to work to do handover. Because ada handover kan. Sometimes, like after delivery only they decided they want to tender, right? Because no one to care for the baby. They can do. We cannot say no, but provided they must come back, handover, then the final month salary we can hold. We have rights to hold. The final month salary is not considered the 7 days category, is not fall. You know, salary must pay by 7th, right? Final month salary until handover then we can hold. That's the checkpoint, checkmate. We can do, okay. Now, when can commence your maternity leave? When can commence? General rule, because you know your due date, right? Normally, kita tahu due date. 30 days before, we can commence our maternity leave. So, meaning to say, after give birth, you still have 68 days saja. Okay? Because earlier, kita kan ambil earlier, 1 month. So, remaining 68 days. If you want to go for early, before the 60 days, okay, 50 days, ada 50 days, then 20 days is your annual leave will be deducted. If your annual leave is finished, then it's considered unpaid leave. Clear tak? Sometimes employer feel pity you because boleh jangan, you want to wait until your last day. Tak boleh jangan. Employer say, please go for leave. And 14 days before your due date, you can go for leave. Upon employer request, sebab employer takut bila akan burst. Mereka boleh minta, we all can go. Mutual lah. No, your maternity leave akan start. Maternity leave. See, employer, all these are specifically specified. Nanti kan I share kan, I got summary version so that we can understand. When you free, you can buka your akta buku, you can find all this. Akta pun nak ada, semua ada. Even though the unfit like that, unless MC is different, doctor only give she must go for annual leave. Not MC, annual leave. Unpaid leave. Until then reach the 30 days, then we can count as a maternity leave before she gives birth. Okay. Okay. Next. Section 41 sub A. During pregnancy time, employer cannot terminate employee. Strictly not allowed unless these three reasons: willful breach, misconduct, or the company close. You can take everyday MC, cannot terminate. Okay? Memang cannot terminate. Very strict, we are protecting. Usually they try to call and clarify, but they don't reveal the what purpose, PDPA. Mereka tak akan reveal, but whether the MC is genuine or fake, only you can check. Itu je boleh. MC, provided genuine MC, it cannot challenge. Cannot challenge. Cannot challenge. Even good court also cannot challenge. How can doctor jadi kawan baik? Huh? No. I seldom take MC. I MC pun tak boleh because I'm the only person need to help. Okay? So you must find to a pregnant woman and cannot terminate. Yeah, okay. Then misconduct and poor performance. Misconduct, poor performance. But the act, throughout the Employment Act, didn't mention anything about poor performance, but we consider it's come under this misconduct category. Poor performance.
So that's why I have to know a lot of moving companies to issue my moving job as before. So
She must justify with her the medical reason. If anything provided, she must justify. Yeah, she must justify why she cannot perform. Okay. Yes. Yeah. Any termination, we must follow the proper process. Okay. Now, another painful situation for the HoDs and employer. See, after delivery, right? Still for the 90 days, we cannot terminate them. We cannot terminate, they are protected. Because, see, if a female employee completed the 98 days maternity leave, still unable to return to work, but they must have a doctor certificate lah. They can still extend for 90 days. Then we cannot terminate. They can continue 90 days leave. Unpaid lah. Kita tak boleh bagi this one. Unpaid 90 days. We cannot terminate her because medical reason. Depends what types of if they utilize MCBs, then unpaid. If they want to take MC, can. MCBs paid other because MC 14 days. Only 14 days. After that, unpaid. Yeah. If they still have remaining annual leave, we can use that. Other than that, unpaid. Cannot be hospitalized. Hospitalized means must admitted to hospital. Okay? fair, because law want always to be fair to both parties. Okay? Okay, let's see this case. This case is about this woman. Asna Liza is a claimant. I didn't mention here claimant and company because you all already know, right? So Asna Liza, when the company dismissed her, she was 7 months pregnant. 7 months pregnant. What happened? The company case is poor performance. But she said because she pregnant, they terminated. Okay, let's see what God said. Yang ni semua I akan hantar Okay, the company is Malayan Banking, Maybank. Okay, let's see. She was dismissed 30th July 2010 by the Maybank. And then she filed the case. Okay, let's see. Okay, now see the claimant means the woman commenced employment with Maybank as a financial executive on 18 January 2010. At the time of dismissal, she earned 2,000 ringgit per month, but she is still under probation. Okay, she is a probationer. See, she was not served any. The company claiming she's a poor performer, but the company didn't give her any advice. What is lacking in her performance, and also not do any counseling, okay, or any written warning, nothing. And then they terminate her because she is poor performance. So when you want to terminate someone for poor performance, before you terminate, you must do counseling, coaching. That's the PIP. Company failed to do that. The claimant aware that between the period she joined employment with the respondent till her unfair dismissal, she was required to undergo continued training by the respondent. Although she was pregnant at the material time, she had complied with respondent's instruction undergo all trainings. Okay? What the company will do, company asks her to attend all the trainings. So she also attended. But when they blamed her for poor performance, they didn't specify what her poor performance, didn't counsel her, she just attending training only. Okay. The claimant said all this she submitted to the court. On 26 July, she was issued a letter terminating her service with effect 30th July 2010, meaning during the probation time we terminated the 6 months probation. And at no time did the respondent conduct any evaluation or assessment of her performance during her period of employment. So now what the claimant want? The claimant want reinstatement. She wants the job back. So she asked for reinstatement for her position without loss in service or seniority or other relief. Usually that's how people will ask. Seniority means she already 6 months, right? So the 6 months must be remain. It's not like a fresh. Okay, that's the case. Let's see what the company is. The company responding right to her claim. Respondent, due to the claimant's poor sale performance results, so they did not confirm her after the probationary period. Okay, what the court say? Okay, what the court finding? Court say claimant comments the employment on that day. Claimant's service with the bank was terminated with effect 26 July. Write this letter, and in that letter, no reason was given why they terminating her. Okay, no reason was given why terminating her. All these are court finding. And then, okay, what is the law? The law for the poor performance, you must, the workman was warned about her poor performance. Before you terminate, earlier you must warn that person. This is law. All these are court say what is the failure of the company. So company failed to warn before dismissal what her poor performance, and whether to give her sufficient opportunity for her to improve. And notwithstanding the above, the workman failed to improve, then only you can terminate. So you must warn her, must give opportunity. After give opportunity, fail to improve, then you can terminate her. All this didn't happen in this case. So, what's the decision they say? COW means company witness. The company first witness is the Mr. Yo Sungun, her immediate supervisor. See, her lawyer asking him, do you issue any letter to the claimant not achieve a target? In the witness stand, in the witness stand. So when you become a HoD, one day you will stand in the witness stand. Opposition lawyer will ask question under oath. Okay? Asking, then the judge will see what your answer. Do you issue any letter to the claimant not achieve a target? No, because that's the truth. Next question, do you issue any letter in respect of the claimant lack of work? what happened? Company pay her back wages. Since she is a probationer, always remember probationer 12 months. Permanent staff 24 months. Maximum can claim up to the court. Maybe I don't know, the judge is very good-hearted person. He gives full 12 months. Some judges will give, because since she's pregnant, right, the opportunity to get the immediate job is lesser, maybe until she gives birth. So full 12 months because of the unfair dismissal. So total okay, -2,200. She can enjoy her money.
So you did only pay for letter or any conversation. You can show the conversation as a witness that he already informed her or informed her.
Okay. Okay, as an evidence, but it's good documented. WhatsApp also accepted as an evidence, but it's good to document it. Okay, this is a golden question, $1 million question. Okay, who should document HoD or HR? How HR know what's the problem ongoing between you and your staff? HoD, HR will facilitate. Actually, the main burden is on HoD. Gather documents. Okay? Show us all HR will do. After you gather document, you pass to HR, and HR will do their due process. In order to issue show cause evidence, who will get the evidence? PIP, yes. The PIP document we have in our system, the one HR will provide to you. PIP, HoD need to do with the deadline, but you must have one witness, you can call one person. Like every 3 months, like 2 weeks you want to review, right? You can call HR person as a witness. But only you know what are there, because that's your department, right?
If we just do the internal short course, is it?
Department show cause, even warning pun cannot. Every letter officially must come from HR. You after ECR, Employment Communication Record. ECR ada 2 kategori. Sana ada tulis misconduct, poor performance. Make sure you take the right document. ECR ada 2. Misconduct dengan poor performance. That one, yes. But don't do one-to-one, must call one more person as a witness.
Even ECR also.
Yeah. Because then later become I say you say problem, at least ada satu witness. You can call HR one person just to see. Within your department senior staff boleh, if for a fact here HR will go. To be fair lah, to be fair. Don't dismiss performance is kerja je. Tadi buat kerja tu all misconduct. Cuti banyak semua misconduct. Nanti I akan bagi kategori. MC misconduct. MC generally you tak boleh challenge lah. Frequent MC kita boleh hantar mereka for full check up. The one is our rights. We have done that. the difference? Sub 2 for emergency situation, no electricity. Oh, we all emergency, right? Okay, sub 2, maybe one of your colleagues didn't come, so you have to be there to help. You must know the differences. 60 sub 1, work on rest day. Okay, so cannot force you because it's for rights, but out of your goodwill lah. Other one, example lah. Okay, hospital environment is 24 hours. The people must be there. Manufacturing. So that's one. Sub 2, your employer can ask your goodwill to work in emergency, really emergency situation, something like any accident at workplace or any like a defense or security reason or any life-threatening event or any interruption which cannot foresee suddenly happen. Fire, you just sitting at home, your employer, hey, come, our factory on fire, come save some goods. Of course we will go, right? We won't say, excuse me, my rest day. Then employer simpan, then take revenge. Okay? You know,
Doctors, yes. Nurses, plus minus.
Ambulance.
Every will have some
reason.
So if let's say allowance, critical allowance, they don't
That's the best deal. That's your right. That's your right. Okay. Okay. Working hours. Untuk nurse, berapa? That one is shift. OT tak ada. Overtime tak ada. 12 jam. Okay, so no overtime lah. Shift you all consider as shift hour. Additional than overtime. Okay. 68 sub 1 is about hours of work. Okay, our old before the amendment, for 1 week maximum hours of work. What is the maximum hours of work before the amendment? 48. Yes, 48. After the amendment, 45. Okay, maximum in a day. 8 is your normal working hours. Maximum 10 hours. Cannot go beyond 10 hours. Sometimes the sales, not salesperson, what we call in the shopping mall, salesperson, right? They say 10 to 10 their working hours. 10 to 10 means 12 hours. 12 hours is not your working hours. 2 hours rest. 1 hour is their lunch hour. 30 minutes they can split. They only work 10 hours. Next time when they say you're working for 12 hours, don't rest. Only 10 hours. 2 hours is resting. Okay? Because 12 hours cannot work. Maximum is 10. Okay, under this section, okay, my work starts at 9 o'clock, right? I only can work one stretch for 5 hours. After 5 hours, I must get at least 30 minutes rest. That's the law. law. Cannot 8 hours without rest, I cannot work. Law require employee cannot be required to work more than 5 consecutive hours. Consecutive means continue. Okay. After 5 hours must get 30 minutes break. Daily limit 8 hours. Beyond 8 hours, overtime, but only for the category of people like 4,000 below or manual worker. Like normal people, we don't have. This one, spread over period for the 12 hours. It's not 12 hours. They will have spreadsheet how what their rest time. 10 hours is the maximum. Cannot exceed 10 hours. That's a law. And then weekly 45. Last time is 48. Sekarang 45. Okay? That's a normal hours of work. Now, for hospital, we have shift work. Morning, evening, night. 3 shifts. Okay. For the shift hour, okay, this paragraph is the summary version. Okay, how for any shift hour worker, not only for nurse, for any shift hour worker, they can work more than 8 hours in a day. More than 8 hours. More than 45 hours in a week. Exception. Provided it's 3 weeks. Calculated, divide 45. That's the rule. Any shift worker. Because sometimes the company need them more than 8 hours. Provided maximum is 3 weeks. Total up, divide 3, 45 per week. Because if you see the first week work for 50 hours, second week 40, third week 45. Holiday. Okay, under the Employment Act, 7 days. In between, they can request which day they want. Duty roster, then you pandangkan
There's a prolonged working hours because first week on Monday, second week is based on Saturday. So meaning that more than 7 days. But that's because more relaxed.
yeah, anything concept from nanti kan any problem then it looks like we don't use them.
We try to put public holiday based on Romania, but some we use to want to keep. So yeah, because it's like
Any some kind of document, dependency part, then okay. Okay. Under this Act, 11 gazetted public holidays. 11, okay? Meaning to say that 11 days you will be on holiday with pay. Out of 11, 5 are mandatory, compulsory, which are National Day. Our Merdeka is a compulsory, and birthday of Yang di-Pertuan Agong, and birthday of the ruler of that state, like Negeri Sembilan means Negeri Sembilan Sultan, and Worker Day, Malaysian Day are compulsory. 11 minus 5, balance remaining is 6. Then 6 days up to the employer. For example, Deepavali, my employer didn't give me leave, I cannot not give. Because it's up to the employer. It's not a mandatory. So the 6 days up to the employer. Okay? Annual leave. Annual leave, you can refer to your policy ke dalam this one you have offer letter there. Okay, we usually will refer to the offer letter. This one as a guideline only. Guideline. Section 60E sub 1 is about annual leave. Okay, sick leave entitlement. Before amendment, this latest amendment, sick leave, hospitalization leave, overall altogether 60 days only. Your 14 days MC within that 60 days. But now under the new amendment, they don't touch your MC. Add 60 for your hospitalization. Yes. The moment discharged, no, not consider hospitalization. They must admit it. No, yeah. the 60 days. But now, MC is MC, hospitalization is hospitalization. Okay, now, paternity leave, also new amendment. Under section 60FA, paternity leave, okay, entitlement for 7 consecutive days, paid paternity leave means one stretch. And the limit, this is the question, limitation number of confinement, 5, regardless numbers of spouse. Legally married. Legally married. Legally. Boleh lima kali. Tapi macam for Indians, kita tak boleh, non-Muslim tak boleh, kena divorce dulu lah. Okay. Okay, you must notify. Okay, there are two rules. You must notify your employer 30 days before the due date, because you know the due date. And also another sad story, you must work with the employer for at least 1 year to be qualified for the. Sudah 1 tahun lah. Sudah 1 tahun. Sudah 1 tahun dekat selesai. Dah, dah boleh. Everyone care for you actually. Okay. This one also baru. Flexible working arrangement. Okay. Flexible working arrangement is allowable under the new act. You can vary your hours of work, meaning to say 8 hours is 8 hours, maybe you start 10 to 7 macam tu. And your days of work and place of work. Provided you must written request within 60 days. If the employer not approve your request, they must reply, black and white, and must give reason why. For example, nurse boleh work from home. Better kita datang ke pejabat. Doktor boleh? Boleh tak doktor AI, doktor operate from sini kan? Ada pun soalan? Okay. Ini pun new amendment added discrimination in the workplace, 69F. Okay? You can complain if your employer didn't take action, can complain. Then if it's proven, 50,000 penalty. So what are considered as a discrimination? Gender discrimination, race, religion, disability, pregnancy also in the category, marital status and workload, salary. Those are discrimination. You can complain to the $1 million question. Labor department or industrial department? Which department? Labor or industrial? Okay, table ini labor. Okay, complain to the labor department, not industrial. Industrial only when there is a dismissal. Okay. Next topic will be. Everyone will be excited to learn about it. Okay. Sexual harassment also is a new section, but not the recent one. Earlier already added. Okay. Sexual harassment under 81A, 81B. See, employee against another employee, employee to employee, employee against the employer, employer against the employee. All these are categorically written in the buku akta. Okay, now see, when you receive when the company, okay, company receive a complaint about the sexual harassment, employer must investigate unless there is a valid reason to reject it. They can reject. They know these two girlfriend, boyfriend suddenly gaduh, hari ni datang complain. We have so many cases. Actually, they are couples. Couples that the girl got husband, the husband got wife already. After the husband know, the girl turned 360, blame the guy. Ayo. Okay. So ini lagi sekarang tulis polis dengan duduk. Kita gadikan, kita ada gadi. Tapi janji ada susah. Additional information, thank you sir. Male to male, female to female also got sexual harassment. Now no more restriction. Okay, see, after receive complaint, up to the employer to investigate or not to investigate. If the employer feel not to investigate, they must give the reason why. Then the person can go to Director General Labour Office. Okay. So the employer must respond in writing within 30 days if refusing to investigate, can do. And then the complainant can appeal to Director General. Then what happened? The Director General will see why the employer refused. If valid reason, then they also say we are not going to investigate. Otherwise, they will instruct employer to investigate. CCTV, eyewitness. Kebanyakan ada eyewitness tau. I say, you say, that's why very difficult. Kebanyakan tak valid unless you prove lah. Kejap lagi ada satu case very interesting. Okay. 81C, after you decided, the company decided to conduct investigate. So after you investigate, now you investigate, then up to the employer whether to dismiss or not dismiss. Sometimes mutually they go out, suddenly something happen, they come and do report, then we cannot involve, right? Or to downgrade the employee, demotion from manager position, downgrade them to assistant manager, or any kind of punishment up to the nature of the seriousness. If we lodge a report, police is a criminal case. Sexual harassment now they are taking very serious. Police can handle, but internally to close the case, we under our purview jurisdiction, we just handle it, we are and then we give punishment. Further than that, police handle police arrest, we only can assist them. Internally, we have to do our part. Okay. Sometimes, okay, for UCSI construction worker, they also can disturb you, right?
Yeah.
Okay. Then can Ms. Masni take action against the contractor, the construction worker, vendor? Can company take action? Cannot. He is not our employee. Then, yes, recommend that person to lodge a police report. Because we cannot take action against the vendor. Action also we cannot take action. Police. Action for sexual harassment. Then what you have to do? Kan kita ada polis bantuan. Then employee must lodge a police report. Then you cannot take action against patient one. Because patient is the wrongdoer is the patient, right? Bukan, mereka punya then you can take action. Yeah. Must take action. I see. Feminine lah. Yeah, yes. The one can employee we can take action. No, wrongdoer. Who's the wrongdoer? Employee means HR can. Can. Because wrongdoer is the employee, right? We can take action. Because we don't have rights. Then police lah, the employee must lodge a police report. Okay. Section 81D. See, sometimes the employee will go directly to the labor office. They don't complain to the HR. They directly will go complain. Then the labor department assess the complaint. Then they will give instruction to the employer to take action. Okay? See, when they ask you to take action, we must do action means investigation. So do investigation. After investigation, if see proper process lah. If the person is guilty, then we give punishment. Despite the instruction from the labor office, we didn't take any action or investigation, then we must pay penalty. Penalty 50,000. Because we must follow the instruction. Okay? Fail to inquire, fail to inform. After investigation, we must write back complaint to them. What's the outcome of the investigation? Notice this under new amendment. Do we have notice? So this is very important. It's mandatory awareness. Okay, right? Yes. Okay. No, I purposely go look for hospital cases. I search for 10 years, no 15 years cases. Okay. So this case is between Mr. Ng Hwa On and Pantai Hospital Ipoh. Tadi Pantai Hospital juga kan? Okay, let's see what happened. On the claimant dismissed employment 25th July 2011. So dismiss him. Okay, let's see what happened in this case. Okay, this person, the claimant, comments as a credit control officer. Credit control officer. Ya. Dalam department itulah ada isu. Okay, dia bekerja sebagai credit control officer. 2002. He joined the company 2002. After that, you can see the series of dates. He promoted. Then when he terminated, he's an assistant manager. He's an assistant manager when the dismissal happened. So on 8 July 2011, the hospital convened DI, domestic inquiry, because 3 women, not 1 woman, 2 women, 3 women complained against him for sexual harassment. Might be happened, but for in this case, why 3 women? That might be happened. I have feelings when I read it. Evidence was lacking. I think you see. No, and then one complainant didn't turn up for the case during hearing. She didn't stand in the witness stand to testify. So the credential wise, court rejected her complaint. So but she must be there to prove. Okay, even though we had the DI, don't look at the DI. What when they start as a fresh. Everyone must go to court to testify. If one person didn't go, then they will dismiss that particular complaint. Okay. So then alleged sexual harassment when they terminate. Okay, now let's see the complaints. See this, the dismissal letter, Pantai Hospital. Very simple letter. Very simple letter. They just give, found you guilty committing offense sexual harassment, and then you require all property, all money, then that's it. No appeal. Okay, but he did appeal, rejected. But in the letter, no appeal. He must mention. Usually he will mention appeal. Appeal is one of the mandatory. Sometimes the staff don't appeal, they will lodge a complaint, that would be our defense. We say, why didn't appeal? You know? Okay. See, at the time of dismissal, he was earning 4,050 ringgit together with fixed monthly allowance 150 ringgit. Okay, I scroll down, I just highlighted important point you want to take note. Okay. See, this is the point. Always remember. See, after unfairly your company dismiss you, this one general, what you say, I dismiss you. You feel, in the DI I wrongly mentioned this. Don't worry about DI. Whenever you complain, this is the law. See, the fact that an employer has conducted domestic inquiry against his workmen is, in my judgment, entirely irrelevant. For the industrial part, for them, DI is irrelevant. The moment you complain, for them it's fresh. Okay? Irrelevant consideration to the issue whether the latter had been dismissed without just cause or excuse. The finding of domestic inquiry are not binding. Industrial court. That's the important point I want to highlight to you. That's why I highlighted. Later when I share whatever I highlight, just read it. That's a law for the specific category. And constructive dismissal also I have been. Okay? But however, for that is not binding. Let DI fresh. However, they will take into account whether the DI conducted is conducted whether the particular workman was justly dismissed, whether it is reasonably fairly held or not. But the content, they don't care, cannot find. They will hear again, it's a fresh case. Okay? Just this is the important knowledge you should know. Okay, now hospital, see, this is a hospital case. They issue the following. This is the notice of inquiry. Just see, chart, also the chart sheet. See, 3 women, right? First person, Miss Nur Azmina. The one is happened March 2011. Okay, why I want to show this letter? Later I will show what the judge say. Why this person? Maybe this person might be maybe high possibility, because usually I believe that there is, but how he can escape? What God said? Okay, see the first one, March 2011. No specific time mentioned. All this the court highlighted later when they deliver the judgment. See, this woman alleged he fondled her breast in the office, and this incident repeated until June 2011. Why she allowed he abused her? Judge asked that question. 3 months, why she keep quiet? So the truth of the case is question. She can anytime complain, right? Okay. Next, and also few occasion the same complaint. The July 2010 to December 2010, there is also 5 months. Miss Masatil, her allegation, he stroked her breast and also lower part of her body. See, the 5 months, it happened almost every day for the 2 months. Why she allowed, right? And also she said in the car, the same person in the car, maybe because boss, right? Sometimes they will go out. And the person touched her private part and also breast after collecting the check. And in August 2010 to April is almost how many months? Another person, new person, the third complainant, she said he purposely touched her breast and also rubbed his body against her back. Okay, those are the complaints. It's very serious allegations, right? Then they call for DI. Okay, call for DI. And then pending outcome, he was suspended. Okay. Now, during the trial, hospital called for 6 witnesses. First witness, who are primary witness? The 3 complainants. They are the complainant. First complainant. See the highlighted part. Nur Azima Binti, she refused to attend court. She refused. Even though they subpoena her. Subpoena means call them as a witness by forcing them to come. If she didn't come, legally it's wrong. Can send warrant of God. But since read the notes of DI. Notes of DI means during DI we record, right? That recording, the verbal statement, it will generate